Welcome to this short presentation on ABHI's Code of Business Practice, which defines our responsibilities with regards to relationships with healthcare professionals. My name is Phil Brown and I'm the Director of Regulation and Compliance at the ABHI. As ever, if there are any follow-up questions or need for clarification, please feel free to contact me and my details will be provided at the end of the slides. Firstly, it is important to talk about competition law, which is a key element of discussions within all trade associations and is highlighted at the start of all ABHI group meetings. Indeed, all members have to sign when becoming members as a statement that they understand these rules. During meetings, association staff, such as myself, have to be alert to any discussions on commercialisation or company strategies, as these may be considered as industry collusions. There are separate sessions on competition law, and if there is further interest or concern, please contact us again. Moving on to the code itself, it is perhaps useful to consider its development. The European Code of Conduct for pharmaceutical industries was developed in the early 1990s, but it wasn't until the early 2000s that EUCOMED, now MedTech Europe, began seriously working on a code to cover medical technologies. Since its first development, of course, there have been several iterations of the MedTech Europe Code, the latest version having been published this year in 2023. The code includes key features which should define the relationship between the healthcare professional and the industry, and we will go through these in detail during this presentation. The relationship between medtech industry and the healthcare professional is a complex one, but the code enables manufacturers to apply ethical rules with certainty and consistency. These rules are required to be followed by MedTech Europe members and has subsequently been cascaded down to national associations such as ABHI to be implemented locally. This local implementation is not always the same within national boundaries, however. So it is important, therefore, if you are working in a multinational setting, to make sure you understand and apply those national rules. But we will concentrate on the UK interpretation through our ABHI code during this presentation specifically. The first ABHI code was adopted in 2008 and is now currently in its 2019 iteration. With the MedTech Europe Code having been revised and republished in 2023, ABHI is now actively considering the next version of its own code, and this should therefore be published by the end of this year. So what does the code cover, and what are its principles of engagement? There are four main principles. Firstly, transparency, making sure that all interactions that we have with healthcare professionals are open to public scrutiny. Secondly, that all these arrangements with healthcare professionals are equitable and that there is no disparity in payments between healthcare professionals. This should ensure that all healthcare professionals are recompensed according to fair market value. Thirdly, that there should be a separation between manufacturer and the healthcare professional such that there is no collusion or inducement to buy company products. And lastly, making sure that everything is documented and that all of the arrangements, both content and finance-wise, are covered in written contracts. The Code of Practice can be found on our ABHI website, and this slide actually has the link to the web page where you can find the documentation itself. You will also find on this web page details of the complaint procedure in case of any complaint which you may have or may wish to make or raise against other companies or professionals in their ethical conduct. It is important to note that this web page is on the public-facing pages of our website, which means that it can be equally applied to ABHI members as well as non-members of the association, as it should be the industry as a whole who is covered by these ethical practice guidelines. Alternatively, you can follow the QR code on the screen now using your smart device, which will take you directly to the ABHI pages which cover the code itself. ABHI, of course, is not the only trade body in the UK. All of the other relevant trade bodies have similar codes of conduct with the same 4 guiding principles within them. It is fair to say, therefore, that if you wish to apply the ABHI code, you're going to be in compliance with the other codes of practice within our industry. What are the specific interactions with HCPs or healthcare professionals which are covered by the code? Firstly, there are guidelines as to how we as an industry organise and run events, whether these are educational events, company events, or third-party events which we interact with. Also, the code covers items such as grants and charitable donations and what can actually be provided in these instances. It is not unknown for manufacturers in our industry to sponsor posts within specific healthcare institutions or the NHS in general, but the arrangements for those sponsored posts have to be carefully arranged and documented. The arrangements we enter into with consultants and healthcare professionals, particularly with respect to research, is covered by the code. Likewise, any royalties which may be granted to an HCP after that research has been conducted or after any jointly developed products have been placed on the market is also covered. The code governs the provision of educational items or gifts and provides guidance as to the financial limits of these interactions. This also applies to charitable donations. An important aspect of manufacturers' business is to provide demonstration products or samples, particularly at trade fairs, etc. The provision of these demonstration products and the samples are also covered by the code. Lastly, the code has a whole section on how advertising and promotion can be developed, and we'll go into that in more detail. The code is written with the intention of being as user-friendly as possible. The main text of the code is accompanied by a number of questions and answers, which should be able to provide greater insight in how to apply the actual code. The content of these questions and answers is often being updated, particularly as experience will throw up new challenges. Indeed, if you are working with the code and you find areas where it could benefit from further clarifications, please feel free to suggest amendments to these questions and answers. Part 3 of the code provides guidelines on advertising and promotions, which are addressed solely or primarily to the healthcare professional. There are a number of principles to be considered when developing advertising and promotion, and all of these points on the slide are equally important. Understandably, any claim made about your product should be accurate and substantiated. There should be careful consideration when using comparative advertising, although this practice is not forbidden. There should be a provision within any advertising allowing any reader, whether an HCP or a member of the public, to request evidence of any of that substantiating data. There should be references to any published data which is used to support an advert and there should be no disparagement to any comparator or comparative product. There should be a limit on non-refereed or non-referenced articles. Off-use label, of course, should not be included in any advertising literature. Any quotations used should be carefully obtained and verified and should be accurate and appropriately substantiated as in the first bullet point. There should also be the same careful consideration of items such as testimonials and endorsements. It is easy to see that a lot of these advertising and promotion requirements are covered by the same principles which are included within the code itself, such as separation, transparency, equitability, and documentation. Part 4 of the code covers complaints and the complaint process. As a manufacturer, you have the right to complain against any other manufacturer you feel is contravening the code itself. Importantly, these complaints do not necessarily have to be made by the manufacturers. Indeed, healthcare professionals also have the opportunity to complain, as do members of the public. As the Director of Compliance, I act as the initial point of contact for any of these complaints. So please, if you do find areas of contravention, please do get in touch. We have a complaints panel, which is made up of members as independent experts. It is chaired by Mr. Bruce Ash and includes lawyers, ex-Department of Health personnel, clinical experts, as well as a patient advocate. When first received, a complaint is reviewed by the panel chairman and myself as part of the ABHI Secretariat. If the complaint is considered bona fide, it then goes for further assessment through the panel. Once at the panel stage, there is no appeal process, making the panel decision final. For a full description of the complaint process, please refer to the code itself, or alternatively, contact me for more details. It is important to note that for serious breaches of the code, ABHI reserves the right to expel the manufacturer in contravention. Furthermore, those complaints are then published on the website for public scrutiny. Having described the procedure, the number of complaints against the code are, however, very small. In the last 3 years, there have only been 11 individual complaints made. Of these 11 complaints, the majority were seeking clarification on advertising requirements or to the conduct of company and third-party events. The remainder of the complaints covered areas such as sales activities, social events, and the appropriation of intellectual property. As previously mentioned, all bar one of these complaints were resolved through mediation, either mediation between the companies or between the company and the chairman of the complaints panel. Our future iteration of the code, however, may go further in how we publish details of complaints on the website, particularly as this resolution often provides clarity over the application of individual sections of the code. So what's the current status of ABHI's Code of Practice? As previously mentioned, the MedTech Europe Code has just been updated, and indeed since the last revision of our own code, the conference vetting system has become operational. It's fully intended that our new version of the code, which will be published at the end of this year, will include details of the conference vetting system, or CVS, as well as providing details as to how virtual conferences can be held and monitored. It is expected that as medical technology product development progresses and diversifies, we will see a greater integration of the pharmaceutical codes. In fact, we are involved in current discussions with the Department of Health, which is leaning towards more pharmaceutical style disclosure and reporting of HCP transparency information. The 2023 revision of our code, therefore, will probably include many of these new facets. Returning to advertising and promotion briefly, it is important to reiterate that the new European regulations, and therefore the future UK regulations, clearly identify through Article 7 greater restrictions and control of advertising and promotion materials. This will mean that the guidelines included within the ABHI code will be extremely relevant. Until recently, the ABHI code was unique in including advertising and promotion, and it is comforting to see that a lot of the European codes are now following this lead. In addition to the new requirements on advertising and promotion, the 2023 revision of the ABHI code will encompass a number of changes which have happened within Europe over the last few years. These include particularly the changes to direct sponsorship of HCPs with regard to international third-party conferences, being cognizant of code compliance within NHS tenders and purchasing requirements. There is an increasing convergence in alignment with other industry codes, and as an association, we have had a long-running exercise in ensuring that our code is in alignment with other trade association colleagues. We are also anticipating, as previously mentioned, further discussion on mandated transparency, which will be a requirement developed through future consultation with the Department of Health. Lastly, we're looking to update our complaints panel and the way in which it works to make this much easier to follow and to ensure that we can communicate and publish greater and more accurate guidelines. I hope that this short introduction to the code has provided some insight into its content. It's important to remember the four main principles of the code, which are separation, transparency, equitability, and documentation, all of which should be considered in your dealings with healthcare professionals. If you are interested in getting involved in the association on any work surrounding our code, please consider joining the Legal Issues and Compliance Committee. You will be made more than welcome. It finally leaves me to give you the contact details in case you have queries over the code so that you can always get in touch. Please feel free to email me at phil.brown@abhi.org.uk or by using the general inquiries email. Thank you very much and good luck in your compliance activities.